Assalamualaikum wa rahmatullahi wa barakatuh. I greet you in Arabic because maybe it's the holy month of Ramadan, and I think it's also important for us to remember that there are other religions in our country. Is that not true, Counsel?
That's correct, Your Honor.
Would I be wrong to say that the reason why you are opposing this law is because it is not Catholic enough?
No, it's because it violates our Catholic teachings, Your Honor.
Unconstitutional because it violates the Catholic teachings?
Yes, Your Honor, and that is guaranteed under the Free Exercise Clause of the Constitution.
Wait a minute. You are saying that it can be unconstitutional simply because it violates the Catholic doctrine?
Yes, it can be unconstitutional on that basis.
Do we have separation of church and state,
yes.
Counsel?
Yes, Your Honor.
And the state is the Catholic doctrine?
No, Your Honor.
So there should be a difference between what the state says and what the Catholic doctrine may say. Is that not true?
That's true.
Yes, and therefore, you cannot expect this court, a secular one. We are not the Congregation of the Faith, nor the Darul Ifma, that we should declare it unconstitutional on the basis of a view of a religion. Is that not correct?
I beg to disagree, Your Honor, because while the majority of the law is secular, the provisions that we are objecting to, particularly Section 7
so your position
and Section
is
23.
That there is a violation of the Constitution simply because it violates Catholic doctrine?
No. It violates religious freedom. It happens that the objector is a Catholic, Your Honor.
And everything that the Catholic doctrine says must be in the law or should not be should not be contradicted by the law?
Oh, we're not saying that, Your Honor, because if there is a compelling state interest,
constitutional test for determining whether the concerns of a religion may be taken into consideration in relation to a secular objective.
Can you repeat that, Your Honor?
Can you give us the existing constitutional test to determine whether doctrine of any religious faith should be given consideration in relation to a secular objective?
The latest is your decision, Your Honor, in Estrada versus Escritor. Before that, Ebranilag.
In Estrada versus Escritor, would you know the voting of the court?
I think it's a close call, Your Honor. But
is it enough to establish ratio decidendi?
I think if the en banc decides on that basis, then it should be law.
I mean the number of votes. Are you sure that there was 8 votes in favor of the ponencia of the Chief Justice, then Justice Puno at that time?
I don't know, Your Honor.
There was none. In fact, there were 2 separate opinions and very strong dissents by 5 members of the court. Is that not correct?
Could be, Your Honor, because it's not published.
What would be the precedent that we can use? As far as we are concerned, we are supposed to follow the Constitution, and Article 3, Section 5 does say that there are 2 important parts to religion and the state. One is non-establishment. Let's just do away with that. This has nothing to do with the non-establishment clause.
That's correct.
Yes, because as far as we are concerned, there is no religion that is being favored by this particular law. Is that not correct?
That's correct.
So we go to the second part, the free exercise of one's religion, correct?
Correct.
And in many instances in the past, here, abroad, many other jurisdictions, there have been conflicts between religious doctrine and secular objectives. Is that not right?
That's right, Your Honor.
Yes. And again, may I ask, what, for our guidance, what do you think is the existing standard that the court uses to determine whether the secular standard becomes dominant or it is the religious expression that becomes dominant?
I think the test should be, if you're saying, Your Honor, that Escritor is that effective as a stare decisis, then your decision in Ebranilag should provide a test, which is grave and imminent danger.
Again?
In Ebranilag, I think the court said that only a grave and imminent danger.
In Ebranilag?
Yes, I think so. Will override religious freedom.
Perhaps you can cover this in your memorandum.
Yes, we will.
Definitely, are we in agreement that we cannot declare it unconstitutional for the Catholic Church?
That's correct, Your Honor.
That's correct. Neither can we declare it unconstitutional for Islam.
Of course, Your Honor.
Because we are, of course, a secular court, and we are looking at the Constitution, and as far as we are concerned, there is separation of church and state.
Yes, but you have the duty to apply the Constitution, Your Honor,
Definitely.
including the free exercise clause.
Definitely, we took an oath to it, and definitely, of course, there are problems in relation to the intersection of religion and the secular objectives of the state.
Yes, Your Honor.
Yes, and you will help us in your memoranda clarify where the test is and apply it to this particular instance. Is that not correct?
Yes, we will do that, Your Honor.
Thank you. Are contraceptives dangerous drugs?
The studies say so, Your Honor.
Because there are contraindications whenever you use contraceptives, right?
That's an indication that it could be harmful.
Okay, here is a drug. These are the contraindications. Liver enzyme abnormalities, persistent elevations in hepatic transaminases can occur. This is so dangerous I cannot even read it. Skeletal muscle effects. Example, myopathy, rhabdomyolysis. You know what this drug is?
No, Your Honor.
It is rosuvastatin calcium, otherwise known as Crestor.
Castro, I'm taking that, Your Honor.
Yes. Do you know that it's a dangerous drug? Because there are contraindications.
There are contraindications,
but we
correct.
do not ban it simply because it may have side effects, correct?
Yes, because it is a unique medicine, like a contraceptive, Your Honor. It serves a purpose.
Okay,
because
here's another drug. The contraindications are hepatitis, acute liver failure, giant hives, decreased blood platelets, decreased white blood cells. This drug is called paracetamol. So it has those contraindications too. So may I just clarify, because you did in some interpellation a while ago, say that it is dangerous to one's health, these contraceptives, because it has contraindications. Now, are we saying that just because technology produces drugs or certain methodologies which always have a side effect, that it should be banned by the state?
Your Honor, the premise is the two examples that you gave are actually medicinal curative. The contraceptive is not of the same league. It does not serve to cure anything. Even paracetamol serves a curative purpose. Crestor more so. But not quite with a contraceptive. They are not medicines.
The law says in Section 9 that in spite of the fact that your claim is that it is not medicine, of course you will cover that in your memoranda, that it does say that it has to go through testing at the FDA level, and there will be also public hearing in order to determine its side effects or whether it should be banned or whether it should not be offered to the public. Is that not correct?
Section 9 appears to contradict that statement, Your Honor.
Why?
Section 9 preempts the FDA practically because it says Section 9 reads, the National Drug Formulary shall include hormonal contraceptives, intrauterine devices, injectables, and other safe, legal, non-abortive fashion and effective family planning methods. In other words, the very law classifies the preceding contraceptives as safe.
So in other words,
hormonal
contraceptives here is a generic. It means that each and every manufacturer, each and every drug, pill, that claims to have hormonal contraceptives in it must undergo testing under the FDA.
But how can you reconcile that when the law itself says they are safe?
I ask that you answer the question.
Yes, Your Honor, sorry.
We're just getting some clarification to help us aid in our decision. And I'm not here to debate with you.
No, I'm sorry, Your Honor.
Yes, we are here to clarify matters. Is it possible that hormonal contraceptives here refer to a generic? That each and every pill which appears to be or claims to be a hormonal contraceptive must undergo testing with the FDA?
Yes, if that's the premise.
Is it possible, because it has to undergo testing with the FDA, that at the end of the day, if you are right, that none of them can be approved by the FDA?
Yes, Your Honor.
Yes. And therefore, would you agree with me that it might be too premature at this time for us to say each and every pill manufactured by any manufacturer company is now an abortifacient or should not be allowed. Or that we take a drastic action of declaring this as unconstitutional without going through the process outlined in Section 9.
If you read the provision, Your Honor, it seems that the FDA, as I said, is not given that discretion to examine the properties of these hormonal contraceptives as probably being unsafe. The law itself says
is there a
that they are safe.
manufacturer that calls the drug itself as hormonal contraceptive? Is that the name given, or is that the generic label? Like, for instance, paracetamols, or for that matter, headache relievers, correct? And in each of these particular cases, the particular manufacturer undergoes the procedure. Is that not correct?
That's correct, Your Honor.
Okay. Now, let's go to another point. Do we have the power to declare a law as unconstitutional because we thought that the Congress should have a different priority for its time? Again, may I repeat? Do we have the power to declare a law as unconstitutional because we think that Congress should have attended to another evil prior to this particular law?
No, Your Honor.
So for that matter, you did say that there are other diseases out there
Yes,
that
Your Honor.
Congress should have covered with more all-encompassing law. That cannot be the basis for us to declare the RH law as unconstitutional.
I mentioned that in the context of equal protection, Your Honor.
How?
Because if it is true that the premise of this law is to prevent maternal deaths, and that has been repeated many times over in the media and even during
Yes,
the
again.
deliberations.
If Congress wants to attend to maternal deaths one at a time, but not all at the same time, because it cannot, it has to take priorities, right? Can we declare a law as unconstitutional simply because, in our opinion, we unelected members of this government, that government should have taken care first of, let us say, malaria or tuberculosis, etc. Can we declare that law as unconstitutional? Even
Yes.
under equal protection?
Even under equal protection, and also in obedience to the duty of this honorable court to determine whether Congress has gravely abused its discretion or acted arbitrarily. I think that's the point of the petitioners, Your Honor.
Okay. You mentioned the conditional cash program a while ago as part of your argument. Is that pleaded in the pleadings that you submitted to the court? Your allegation that the RH provisions have already been incorporated in the conditional cash program, because that's a very serious allegation now that we have an SQA. Has that been pleaded in your pleadings?
In general terms, Your Honor, in the petition of Couples for Christ, I think it was mentioned as one of the grounds, Your Honor.
Okay. Now, does this court have the power to police sexuality?
No, Your Honor.
The choices of people, whether they should have sex or not have sex, whether they should have sex with one partner or 1,000 partners, does this court,
No,
does
Your
the
Honor.
Constitution have the power to regulate that?
No, Your Honor.
Okay, thank you. Now, let's just go to more specific provisions. Do you have the law with you, counsel?
Yes, Your Honor.
Can you help me? Can you read Section 3, Paragraph A?
Section
3, Paragraph A.
Paragraph 8, Your Honor.
Yeah, A, as
A.
in apple or alpha. Sorry, or Attis.
Section 3 reads,
A.
Guiding Principles for Implementation. This Act declares the following as guiding principles. A. The right to make free and informed decisions, which is central to the exercise of any right, shall not be subjected to any form of coercion and must be fully guaranteed by the state, like the right itself.
Okay. Can we go to Section 23, the penal provision, subparagraph letter B, as in Bravo?
Any public officer, elected or appointed, specifically charged with the duty to implement the provisions hereof, who, personally or through a subordinate, prohibits or restricts the delivery of legal and medically safe reproductive health care services, including family planning,
The next clause is important.
or forces, coerces, or induces any person to use such services,
Any public officer elected or appointed, who forces, coerces, or induces any person to use such services which refer to reproductive health can be criminally punished. Is that not correct? Fair reading.
That's correct.
So no public officer can coerce a person to actually make use of artificial contraceptives. Is that not correct?
That's correct, yeah.
Yes. Letter C. As a matter of fact, can we read it? Same
section. Any employer who shall suggest, require, unduly influence, or cause any applicant for employment or an employee to submit herself to sterilization, use
any modern method of family planning or not use such method as a condition for employment, that too is a crime, correct?
Yes, that's correct.
Now, will you agree with me that there is no compulsion under this law for a woman or a man to make use of artificial contraception?
You mentioned, as a general answer, yes, but I mentioned the unique...
We can only go by the text of the law.
Okay,
because,
by the text of the law.
We can engage in moral argument or ethical argument or religious argument, but we might be wasting the time of this court because this is a court of law again. Again, as I said, the text, does it compel a woman, even a poor woman, to actually make use of artificial contraceptives?
By its text. Yes, Your Honor, it does not.
It does not. You said by its text. What else is there?
I mentioned the unique experience of the poor through the integration of the anti-poverty program. And
wait, are we attacking the anti-poverty program now?
No, Your Honor.
Okay. Now, can we move on to, again, since you have the law with you, Section 3, subparagraph L.
Section
3, subparagraph L, as in Leonen.
Active participation by...
No, Section
L?
3, yes.
Okay. There shall be no demographic or population targets.
There shall be no demographic or population targets.
Yes, Your Honor.
And the mitigation, promotion, and or stabilization of the population growth rate is incidental to the advancement of reproductive health. Will you agree with me that this bill is not for population control?
I'm sorry, I will not agree, Your Honor, because that provision is precisely qualified by an admission that the effect of reproductive health program is to mitigate stabilize. I think the dictionary Webster will define or defines mitigation as the lessening of a particular impact. So if you read the law logically, it says that, okay, we will not have any population targets, but the effect of this is to mitigate and manage population growth. To me, it says a lot about an attempt to control population, Your Honor.
Is incidental to the advancement of reproductive health. Isn't that a phrase also in the text of the law?
Yes. But it also admits that that is a necessary consequence of the reproductive health program.
By the way, counsel, who dies when we say maternal mortality? Is it the man that dies or the woman?
The woman, Your Honor.
The woman. Who gives birth? Is it the woman or the man?
The woman, Your Honor.
And in terms of maybe reproductive stuff or reproductive health, what's the participation of the man? You don't go into graphics, just maybe in general. Simply to partner with the woman, correct? And produce the element, the sperm, in order to be able to fertilize the egg. But it is the woman that carries the ovum and the fetus for 9 to 10 months, depending on how long the term is, correct?
Correct, yeah.
Yes. And equal protection of the law does not mean simple equality, correct?
Yes.
It means looking at the just deserts, meaning to say looking at what should be allocated to people with the most burden, correct?
Equal protection, Your Honor?
Yes. In terms of maternal mortality, it's the woman that dies, correct?
Yes, Your
And
Honor.
therefore, there should be a law which actually helps out protect the health of women as they give birth. Is that not correct?
Yes, Magna Carta actually addresses that.
More than any law that should protect the man in terms of birth giving, because the man has very little participation.
That's correct, Your Honor.
Correct. Okay. Now, in terms of information, who has more information, the rich or the poor?
The rich, probably,
The
Your
rich
Honor.
has more information. Does this law have a bias towards providing more information to the poor?
I think so, Your Honor.
Yes. And again, does this law compel anyone to actually make use of any of the methods that are presented to them?
Integration clause might suggest that there is coercion, Your Honor.
Which clause?
The provision that the reproductive health program, family planning, will be integrated into the poverty alleviation program
But
government.
it's a crime. Any public officer who forces or coerces, correct? So that therefore would come within the provisions of the law, correct?
That's correct.
So therefore, is there any compulsion for a poor woman, given the information, to actually make use of artificial?
I think so, Your Honor.
How is that again?
Because we're talking of the poor. They have no choice. They need the 1,500 peso cash dole out every month. And one of the conditions...
Again, counsel, we are looking at the RH law, not the conditional cash transfer program. Here, I don't see the 1,500.
But I see the integration of the poverty alleviation program. I think this honorable court can take judicial notice of that.
This judicial notice concept, it is to take notice that there is 24 hours in a day. Is that not correct? Or that the
Yes.
sun rises and sets, correct?
That's right.
But there are certain truths that may be believed by some people which may not be truths of others. Is that not
That's correct. That's correct. Yeah.
And the gold standard might be science. Is that not correct?
Among others, yes.
And as I asked, I think the other counsel at the other time, would you agree with me that the science on both sides are robust? That there is science quoted by the petitioners, and there is also science quoted by the respondents? Or would you say that their science are false?
Are you referring, Your Honor, to the issue of right to life?
Generally.
Because I'm referring to a specific situation here, provision that integrates the poverty alleviation program in the...
No, I went on. I moved on.
I'm sorry.
In terms of the question. This issue of judicial notice. Can we take judicial notice of a fact that is contested by several scientific associations, organizations, and the findings are still, shall we say, being debated upon?
No, Your Honor.
Okay, thank you. Let us take a look at Section 14, which is part of your oral arguments. And this has something to do with education, correct?
Yes, Your Honor.
Yes. Section 14 says two things. One, age-appropriate and developmentally... I'm sorry, can you read that portion?
Development appropriate. The state shall provide age and development appropriate reproductive health education.
Not only that, it says to be taught by adequately trained teachers.
Yes, Your Honor.
Not only that, it says that it can be integrated into several different types of courses in the curriculum, such as values formation, knowledge and skills, self-protection against discrimination, sexual abuse. Not only that, it does say that the DepEd shall formulate a curriculum used by public schools and may be adopted by private schools. And finally, that only after consultations with parent-teacher community associations, school officials, and other interest groups will the course be actually established.
That's correct, Your Honor.
Yes. What's wrong with this?
I said there are at least three constitutional violations for that provision, Your Honor. One, it violates the equal protection. Why? Because it makes sex education mandatory public schools, but optional in private schools. The effect of which is, with regard to parents of children in public schools, they will have no choice but to accept sex education for the children.
Is there no reason why it is mandatory in public schools and optional in private schools.
Whatever the reason, it does not qualify as a valid classification, Your Honor. Because if the purpose of sex education is precisely to educate the children and students about reproductive health, then it should apply equally to all the students regardless of whether they are in public or private schools.
So there should be sex education mandatorily provided in private schools?
No, what we're saying is that it has to be optional because there's another constitutional provision being infringed. The right of the parents, the natural and primary right of the parents to rear their children for moral development.
So because there is the natural and primary right of the parent to teach their children sex education, the schools cannot teach it?
They cannot. Because the state's obligation is to support. In the old Constitution, I think 73.
As a matter of fact, I should be able to teach my daughter law. Therefore, schools should not teach law. Can we follow that logic, Counsel?
No, because law has nothing to do with beliefs.
Is it not possible that the schools simply supplement the values already created in our children by us and by our churches? And the only thing they try to do is try to supplement whatever the parents may not know yet about sex education.
Compulsory sex education, Your Honor, is not supplementing. It is actually usurping that primary right of parents to educate.
Does it say here that the parents may not teach their children sex education?
But it does not, but it preempts. Because
does it say here that our churches may not proselytize on values that are embedded in the sexual act?
It is implied, Your Honor, that that right will be undermined by this mandatory sex.
Is there a violation of such rights by the family and by the church, of such rights by an institution of a religion?
I'm sorry, Your Honor?
If it is not prevented here in the law, all it says is that it provides courses for sex education. But it does not say that the parents may not teach sex education.
The problem is that it is mandatory. The fact that it is mandatory immediately takes it out of the primary duty of parents to educate. Primary means the chief, the initiating, the first. What this mandatory requirement
does. At 3 years old, your children are with you. You teach them first. At 4 years old, you teach them first. When they come home, you teach them. When they're adolescents, you correct their mistakes. That's primary role, correct?
Except that our children spend more hours in school than at home.
May I ask, is there anything in Section 14 which actually says that the family may not continue to teach their children?
There's none, Your Honor.
Okay, thank you. That's all, Chief.